If you or someone you care about has been charged with lewd or lascivious battery in Florida, it is important to understand that this is an extremely serious felony offense with potentially life-changing consequences. In Florida, lewd or lascivious battery generally involves unlawful sexual activity with a minor between the ages of 12 and 16. A person may be charged if they engage in sexual activity with a child in that age range, or encourage, force, or entice the child to engage in certain sexual conduct. Importantly, under Florida law, consent is not a defense. A child under the age of 16 is legally incapable of consenting to sexual activity. Lewd battery is typically charged as a second-degree felony, punishable by up to 15 years in Florida State Prison, up to 15 years of probation, and a fine of up to $10,000. But the consequences often extend far beyond incarceration. A conviction for lewd battery can also result in mandatory sex offender registration, severe restrictions on where a person can live or work, limitations on internet usage, and long-term damage to employment opportunities, professional licensing, and personal relationships. Because of the serious penalties involved, what you do immediately after an allegation matters. If law enforcement contacts you or asks you to come in and tell your side of the story, you should be extremely cautious. Statements made to investigators can and will be used against you. An experienced criminal defense attorney can evaluate the evidence, identify weaknesses in the state's case, challenge unreliable allegations, and work to protect your rights and future. If you've been charged with lewd or lascivious battery in the Tampa Bay area, call Hunt Law at 813-787-4849 for a free case consultation.